Yes, welcome to the No State Project, live from the fortified compound in Mesa, Arizona. Glad to be with you here, streaming live on my YouTube channel, which of course is No State Project. Get subbed, and hey, you'll always know when we're going live because it's at 3. It's always well, I guess I should be. It's 3 o'clock Mountain Standard Time every time, so it's going to change here in a few months. But I guess it's better to just say it's always 6 p.m. Eastern Standard Time. Glad to be with you here for this Wednesday. It is episode 77 of the big broadcast. Commercial free, so we'll do our best to get to everybody. As always, thanks for the continued support of the show. Good friend Bill up in New Hampshire, and of course and Dan also. So if you want to help support the show, it's kind of needed. You can go to markstevens.net and you can do that. So I'm going to get to the calls in just a moment here. I am expecting someone, a mate from down under. So it's been tough to get him on the show because it's actually Thursday down there, and so it doesn't always work out. So we're hoping to get him on really real soon. So just please be patient with me about that. I'm not putting anybody off over there, but we have been trying for a few weeks to get him on. So we'll see. And Australia, we haven't had someone from Australia call in a long time. So it'll be pretty cool to get there. I will have a video. I have a couple of details I got to hammer out first before I do the video. But we've got somebody in New Jersey. He's actually from New York, but he got 5 charges in New Jersey. And one of them includes a lower end felony. And so all 5 charges have been tossed out, and I will have a video with that. I wanted to do it today, but of course, again, there's some details you'll understand once you see it, why I wanted to get that hammered out before time instead of doing the video and finding out later. Because contrary to what people may say, I want to have as much context as possible before I do a video, especially when we're saying that what I teach here at the No State Project, basic logic and skepticism, that when we apply that into the court system and has been effective, I want to have the context to know that this was the cause, or that it's very plausible that is the cause. So look for that. Hopefully we'll have that tomorrow. Something happened really recently, and it's something that doesn't happen very often. So because it's so extremely rare, I want to talk about this. There's a guy named Roy Oliver, and he was a police officer. He actually shot and murdered. Yes, and it's murder. So I'll get to this in a second. A 15-year-old black man, or black child, actually, he shot into. I'll give the details in a second. He shot into a car that was driving away. And it's so extremely rare for police officers to even be charged, but for them to be convicted, wow, that is really, really rare. So before I get into, I want everyone to see what this piece of garbage looks like. That is the police officer. I hate to do it this way, but I don't have the option of using that other software, so I can do things live on the air and show documents and whatnot. So this is the piece of garbage. He's not a cop anymore, but he was a cop when he did this. And I guess the video, I guess the facts were so absolutely damning that they not only charged him and prosecuted him, this piece of filth, they convicted him. So this is from ABC in Dallas, Texas. Jurors at the time that this was written yesterday, because this is August 29th, and I think this came out very early this morning. So it actually hadn't come out yet, because like what you see here on my phone, well, maybe you can't. He's actually been convicted. So this article is from yesterday. So I guess I pulled up an article that was a little too old. The jurors deciding the fate of a former Texas police officer who was convicted of murder. Oh, okay. So he was convicted. Okay, so I got the right article. He was convicted. They're just doing the sentence. And Wednesday marks the second day of the sentencing phase of the trial of Roy Oliver, who was convicted Tuesday for the 2017 slaying, the murder of 15-year-old Jordan Edwards. Edwards was killed when Oliver, a police officer in Balch Springs at the time, fired into a car full of black teenagers as it drove away from a house party. In a rare guilty verdict in a police shooting case, the Dallas County jurors were not swayed by Oliver's claim that he feared for his partner's life when he fired into the vehicle. His partner told jurors he didn't fear for his life. Oh, man. See, and that's what the cop suckers, they have a real problem. When you have two cops that you said, people tend to work, oh, hometown hero. But when you have two of them telling a different story, who are you supposed to believe? Now, I would say that the average person, especially those of the Trump and Republican persuasion, would obviously believe the police officer who did the killing. Oh, we feared for our lives. Wow, jurors who actually didn't buy it. I guess they weren't really convicted by the two stories from separate police officers. Gas echoed around the courtroom as the verdict was read. Edwards' relatives sobbed and hugged prosecutors, waved their hands in the air, and proclaimed, "Thank you, Jesus," after the jury left. Now, they had a tiny taste of some very rare justice there. His father, Odell Willie Edwards, briefly spoke outside the courtroom before heading back to begin listening to a sentencing phase of the trial. He said he was thankful for the decision of the jury, which featured 2 black members out of 12 jurors and 2 alternates, and he felt like jumping for joy. I just want to say I'm happy, very happy, adding it's been a long time since he felt that way. He faces between 5 and 99 years. I should have done a better job of looking up how much time the guy got. I guess I could look at the phone over here and see just if he's been given. No, this isn't telling me. This isn't giving me how much time he's actually gotten. So I'll report that on the Saturday show and let everybody know how much time this piece of garbage got. Wow. So, good on the jury there in Dallas, Texas. Actually, having your child murdered, I can't even begin. I don't think I could ever be happy again, even if the killer, was tortured and had his given his due. I don't know how you get over the brutal murder of your own child, even if your child died in a nonviolent way. I mean, it's still your child, but to be brutally to be murdered like that, that's pretty bad. So good on them in Dallas, Texas, who actually brought this murderer to some level of justice. It's very small level of justice, of course, because it was his child. But it's some justice, nonetheless, and extremely rare. So does this show that the system works and that cops are not favored? No, it just shows that here they did the right thing. This time they did. What? Out of the other 3,000 times the police officers have killed somebody who was unarmed, where they were blatantly lying and planting evidence, fear for their life, doesn't wipe any of that away, which is really unfortunate. Actually, you can't do that. So, again, his name is Roy Oliver, but what's more important is that Jordan Edwards, the teenager who was murdered, his family has and the community has some justice that this killer is going to hopefully spend the rest of his life in prison. So yeah, we'll see what happens. I mean, it is murder, so and Texas has the death penalty, so they could give him the death. I'll say it. I think justice would be to have the mother be able to shoot this guy. Let the mother take care of this guy. Gutless coward. See, that's what cops think. They have a license to kill us, especially if you're not of the white persuasion. Well, I shouldn't say that. So if you're not rich, if you're not in particular neighborhoods driving particular cars, if you're not rich, then you have cops think they have a license to kill and do whatever the hell they want to us. The way it works. It's the way it works. So what do we got over here? I'm going to put the cans on. I'm not seeing a mate from Australia getting in the queue. So what we're going to do is we're going to take who is first. We have area code 407. You are live on the No State Project. What's your name? Where you calling from?
Hey, is that me?
That is you. What do you got for us? What's your name? Where are you calling from?
I'm first. My name's Paul. I'm calling you from Florida.
Paul from Florida. What do you have for us today?
First time caller. Hey, I sent you an email earlier, Mark. I actually got Brady discovery from a prosecutor yesterday.
Well, give us the details. What I didn't have a chance to look at the email, and even if I did, I'd still ask you to give us the details.
I know. It's basically my driving record and a copy of the ticket. That's all I have here. So I don't know how they figure that answers any of that.
Well, they're going to give you what they the least that the minimum that they have, that they believe that the judges can expect them to give you. Are you the one that mentioned that the judge actually yelled at the prosecutor for not providing discovery?
Yes.
Oh, yes, that's not a detail you should leave out. For everyone listening, if a judge yells at a prosecutor, let me know. That's something we want to know, right in the first minute of the conversation.
Sorry about that.
Oh, no, it's not a big, it doesn't happen often.
So how to respond to that? I mean, other than the normal stuff.
Well, a way to respond to it. Well, let's go through that for those listening. Did you actually get the Brady material that you requested? Did you get the evidence that you requested?
I did not. There's no evidence there from what I can tell. So I didn't know how to talk to them about, I'm supposed to go to a pre-trial meeting next. So.
Okay, well, what you want to be, that's usually at least 95% of it, or, depending on what issues are raised, should be just between you and the prosecutor. So you have the opportunity to confront them on the issue, on the elements that they didn't give you. Say, I see what you got here, and you could, ask your leading questions. Is the evidence that I asked for, is it in the materials that you provided? And that gets the ball rolling. Okay. At least let them commit. Right there, face to face, let them commit that the evidence you asked for is in that material. And then you can,
that makes sense.
Yeah, and then you can start hitting them, because now you see, look, you always want to look ahead, because you know that they're lying weasels are always going to say and do whatever's necessary to try to get around the fact that they did not provide the evidence. So they're going to say that they don't have to. They're going to say that that's not necessary. That's something that we don't have to give you until trial. All of that last one, I don't know. It would be really, really brazen for them to pull that kind of crap. But we have heard that before, where they try to say that they don't have to give you that discovery, the evidence that they're going to use. They don't have to give that to you until the actual trial, not immediately before trial, but during the trial. So they can, I forgot. Discovery actually means that you can surprise me at trial. So once you've got them pinned down and they've committed that, you've got what they sent you, and then you can just go and start tearing it apart. So you're telling me that the evidence proving that your Constitution and laws apply to me just because I'm physically in Florida is in this discovery material right here. You gave me that. And then, of course, you know what to say after that when they say yes, right?
Can you please show it to me?
Yeah, just point it out. I know you'd probably prefer that I plead guilty. You point that evidence out to me that proves that your laws apply because I'm physically in Florida, and I'll get you a guilty plea right now. The only thing they're going to be able to do, of course, is show that you were in Florida that day. So
exactly,
it's your opportunity to ask. And so if they insist, that's it. Say, exactly how do you plan on proving? What are you going to use to prove that just because I'm physically in Florida, that your Constitution laws apply? What do you got in here to prove that? And if he says your physical location, then you just say, well, how does that work? Exactly how does my physical location prove your Constitution applies? What exactly is your witness going to testify to?
Yeah, and the witness, from the speeding ticket I had on this, from the other so-called trial or hearing, I got the cop to admit that, number one, there was no injured party, and that he did not know what the what a cause of action, what the elements were. So I got that on record because they record everything, so that's good. But my only question is, if they bring up the tickets, is there something I can say, like, it's okay, it's only a ticket, it's not evidence? Like, I guess what's the right terminology, or what's the right way to handle that?
If they're saying that the evidence is on the ticket or the ticket is evidence?
Yeah, either one of those two. Yep.
All right. Well, if they say that the ticket is evidence, so you just want to go through your Socratic method, get them to confirm what their position is. So your position is that this ticket is evidence proving your Constitution and laws apply because I'm physically in Florida. So you got to get that out of the way. Know exactly what the claim is, so that later then they try to say, well, you're taking me out of context. You say, I asked you point blank, are you wasting my time here? I don't appreciate you lying to me like this. And if you're going to be dishonest, I'm going to make a note of it. I'm not only going to complain to the judge, I'm going to complain to the Bar Association about you, and I'm going to file a claim against you with the county's insurance. You may be immune from my lawsuit, but your insurance is not. So that's, we know that they're going to do all kinds of shucking and jiving to try to get around the fact that they don't have the proof instead of just giving you the proof. So we confirm that's what they're, and then you have to ask them, like we already did, what exactly on this ticket proves that the Constitution applies to me, and walk him through that.
Okay.
It's a matter of
the same thing.
Yeah, it's the same that we've already, pretty much covered that. You want to ask him so you can, again, what evidence, what's the proof, or exactly how does this ticket prove your Constitution applies to me? And is your witness going to testify to these issues? Is that, and that gets us to the other part, because in the Brady request, you want to know the witnesses with personal firsthand knowledge that are testifying that the laws apply and you violated them. They have to have personal knowledge of the matters they're testifying to. So that's, again, you want to ask them, because that question kind of leads into that. What is your witness going to testify to? And then you ask, so do they have personal firsthand knowledge to prove that, do they have personal firsthand knowledge of the matters they're testifying to, specifically that the laws apply to me and I violated them? And
well, this will be my fourth time in front of this same judge, and I'm getting a lot more comfortable with this stuff. So I will definitely keep you up to date on what happened.
Well, cool. See, the thing, when they answer you, they'll say, well, I told you it's the police officer. And so, well, yes or no, does the witness have personal firsthand knowledge of the matters they're testifying to, being that the laws apply to me and that I violated them? And if he says yes, well, okay, great. What specific, what evidence do you have to show that he has personal knowledge the Constitution applies to me?
Really appreciate the job you do. I'm looking forward to this one, I guess.
Have you done the role playing?
You know what? I tried to contact you on Skype, and nobody ever got back to me. So, but like I said, I've just been doing it live in the courtroom. So
that's good.
Probably over aggressive, but
that's good. So let's not let that happen again. What you do is Skype me again. And I didn't open up. I didn't. Oh, Skype me again, and I'll make sure that you get into the chat.
Yeah, I've got another month before my next hearing.
Oh, great! You got plenty of time. So, your whole thing is keeping the focus on the prosecutor's claim and the evidence to support it. It's that simple. So, appreciate the call, and
thanks a lot.
Yeah, and we'll see you on the Skype chat. Unfortunately, no, man, I can't. Okay, I'm going to do this once. Is this Kevin? Yeah, see, I can't do it that way. Hopefully, I'm not hanging up all of my calls now. Did I hang up my? Yeah, I'm hopefully the anonymous one. I don't know if that's Kevin from Australia. But yeah, I can't do a call live from Skype on this show. So I have to have you call the caller line, which is 218-632. If you're calling from Australia, it's area code 1-218-632-9399, and the passcode is 2020. So maybe I do have a Skype call here. So maybe we have a Skype caller. Is this Kevin?
No, it's not. It's somebody else.
All right. Well, hey, we'll see what we can do about getting Kevin on the line. What's your name? Where you calling from?
Hey, this is Tom, and I'm calling from the U.S. of A.
Kind of broad.
Yeah, I've called before. You might know who I am, maybe.
You sound familiar.
Hey, yeah. Okay. Good. I called in, and you said that if you're on probation, you're at their mercy. Do you remember saying that?
It sounds like something I would say.
I'm sorry, I didn't hear you.
It sounds like something I've said that if you because it,
yeah. Is that true? That if you're on probation now, that there's really nothing you can do to rectify everything that they've done to you?
Well, there is, but you have to accept the risk that they're going to yank your probation and have you sit in jail or prison while you're awaiting your paperwork to be heard.
So if you put in a Brady request or a motion for anything, that you would have to sit in jail for that?
Well, I'm saying you run the risk of having the prosecutor or the probation officer getting really pissed off at you and doing
You're
that.
right.
I'm not saying that it's absolutely 100% of the time. It might not happen. It might only happen half the time, but you got to let people know the risk that they're taking by doing something like that. You absolutely are risking having your probation yanked by they do that. All he has to do is violate you and you're back in that day.
You're only saying that if I file the paperwork. If I have a lawyer file the paperwork, I don't have to worry about that?
I think you still have to worry about it. It depends on what the issues are that you're raising. And Matt, okay, because
Okay, well, thanks. I did that. I went the other way. I told you I was going to go a different direction or something because it wasn't working the way I was trying to do it. I was trying to do it on my own. So then I hired one of their guys. And yeah, I was able to get in there, and it did piss him off, and I knew it would, because he did more than what I asked for. I asked for him to help me with the restrictions they have on me, and he went for everything. He pretty much cut everything. He wanted to eliminate the whole thing because he knew my case. So he said, your case is, you've gotten punished more than anybody that I've ever seen for not doing nothing. But I've really gotten punished bad. So he went in ahead and filed all that. He pissed the probation officer off. I guess he pissed the judge off and everything, because they declined. They just said declined. That word they used there when he put in for a motion to terminate everything. The judge came back with denied. That's the word they used. Denied.
Denied.
That big word, denied.
So even with a lawyer,
they denied it.
even the lawyer couldn't get an explanation other than one word, denied.
Oh yeah, he got an explanation. He came out and told me and said that he was really sorry and that he wished he had gotten involved earlier and a lot sooner, and that that it was just terrible what they were doing and everything. And I didn't get put in jail or anything, so I figured that I was okay that way. So yeah, you're saying that if I do it on my own, I do my own paperwork with a Brady request, a FOIA request, and the other three things that he did for me. He put in a motion to terminate probation, to take the GPS off or adjust it even. He put three things in there. So they just denied that. And he came out of there. He was a little bit ticked off about it and stuff.
Wow. It sounds like he sounds like you got a pretty decent guy as a lawyer, that he certainly cared about what was happening. He was willing to go.
Well, he did, because I had him a lawyer. I had him as a lawyer before, and he's an older guy. He's a senior guy. And he was really good. He's really, really good. I have to say that about him. When he goes in places, people salute him. He gets respect from a lot of people. He could be a judge, but he never was.
Wow.
Even though that's, big deal. But still in all, I didn't get put in jail or anything. So that worked out okay there. And then that made me think, well, wait a minute. Mark told me that I was at their mercy. Well, yeah, I understand that now. yeah, I am at their mercy anytime. So if I try to do that on my own, they're liable to just go ahead and lock me up, like you said.
It's possible, but here you've had some experience, and it doesn't seem like they're inclined to do that. You're saying that they could have thrown you in jail, even though you had a lawyer doing, oh, screw this, go violate the guy, and it's that simple.
He wouldn't have let him do that. Last time that he worked for me, he got everything that he wanted, that he asked for me. He basically asked for the same thing last time. And he said, you guys are crazy. No, he's not doing that. Bullshit. And I walked out of there, didn't have to do nothing. I got out of everything with him.
Nice.
But this time it didn't work.
Well, I'm glad that, you're able to work with a guy, and it's always refreshing to hear that you're working with, that there is a lawyer out there, because they are out there, that is willing to go to bat for you. And not only that, but the guy has enough clout that, in his reputation, that he's able to have some influence on if the judge is going to go off the rails.
Yeah, and that's the problem. I don't know anybody like that now. There's just nobody I know like that, no lawyer that I know like that anymore. He was the only one. I've hired 3 or 4 other ones, and it just went haywire. They just beat my ass to death with everything they could, and plus more. And it was for the same cause, and the shit's been going on for almost 20 years. So it's the same charge through the whole 20 years. They just been on my ass and just hanging me for it every chance they get, because I disrespect the cops. Basically what it comes down to. They say I do. I have never done anything to them. I don't carry firearms.
Well,
I don't curse. I don't run from them or anything, but I disrespect them, so they don't like that.
What are the specifics that they're saying that you're disrespecting them? Are you saying F the police? I mean, what specifically?
No, he just has no respect for law enforcement. He has no respect for him. He doesn't, I don't know what they mean by that. It's just like I'm supposed to bow down to them when they come in front of me or something. And I don't do anything wrong. Well, I have flipped them off before. That was the last time I did that.
Okay, that's a specific, and so when you do stuff like that, I support you doing that. As far as it's right, it's not immoral, it's not unethical, and they deserve it most of the time. You're going out of your way. So if you've got real dicks, they're going to give you a problem. But before I move,
following me around, he was following me around, and he did it quite often, and I just got tired of it. I really did, and that's why I did it to him.
I understand. Let me ask you,
and I didn't put it out there where everybody could see it. I just hung it down there by my side. I was walking casually, and I kind of lipped it to him too. I didn't say it out loud or nothing. I just, like if you were reading lips, you couldn't hear me say anything, but he could see what I meant, and he could see that down below there was one pointing at him too. He could see that.
If I was gonna, you could always go to, maybe, it's in Florida, so you're probably not going to have many Sicilians or Italians. So just a simple does the same, it does the same trick, and he might not be smart enough for, know enough to think, oh, the guy just flipped me off in Sicilian. So there's also that. Yeah. Before I let you go, because I'm getting more calls, why would you do a FOIA on a state agency?
Because, Mark, they're punishing me for a crime I didn't do, and I'm trying to get it straightened out, but they're like, they want to take everything I've got. They want to take my house. They want to take my life. They want to take everything. Okay, but and I've got the backup and the witnesses to do it, and they don't want to do it.
Okay, but what information are you using a FOIA to get?
I want to know who said what about me. I want to know. They were not giving me any evidence. All they're giving me is the shit that I signed by force by them. Like, you fill this paper out and say you're going to do this for probation, all these rules, and they make me sign that. That's the only thing they've got on me. They don't have any witnesses or anything, no evidence, no DNA or anything on me. And I want to know the FOIA request is who's saying shit about me that's hanging my life like this.
Okay, so you weren't given any discovery material, because that should be in police reports.
I asked for it. I didn't ask for a Brady request. I asked for discovery every time. I didn't know about the Brady request, but yeah, I asked for discovery every time.
Well, what you could do, and again, you are running the risk of being put in jail. You understand that you could do, let's say, a petition for a writ to vacate the judgment that was done in violation of due process, And through that, you can get the material, you should be able to, if you can get past the initial motion to dismiss, you should be able to, because it's a civil proceeding, it's a full-blown civil proceeding, you should be able to then use the discovery process in the higher court to then get the police reports that they're basing and all the reports that they're basing their claims on.
And is a Brady different than a discovery? Because I've never used a Brady.
Yes, at this point, for specifically what we're talking about here is you're asking for a discovery. You want the evidence that they're using against you. Brady is discovery. However, it is a particular type for those who are new. Brady material is information that shows that you're innocent. It's information.
So if I don't ask for a Brady, though, I'm not asking for anything like that. If I ask for a discovery, they can just throw anything they want at me. If I ask for Brady, it's particular, and they have to submit that to me, right?
Yeah, but you have to be.
They can do whatever they want.
No, well, discovery. No, they're not supposed to do whatever they want. They're supposed to be giving you the documents that they're using, the documents and a list of the evidence that they're using against you to support their claims. That's what they have to give you.
And wouldn't that include a doctor's report or DNA or evidence of a gun or a witness, or wouldn't that include discovery?
Yeah.
Wouldn't they put that in there and give you the paperwork and say so-and-so said this?
They're supposed to.
He's seen you do that?
Yeah.
And here's the gun that you shot the guy with, or stuff like that.
Yeah.
But I never get anything like that at all. Nothing.
And that's why for you or anyone going through that, what we got to do is be pretty aggressive on the discovery. If they're not going to throw it out for prosecutorial misconduct and a lack of evidence proving jurisdiction and any wrongdoing, then you have to file to change the judge, or just go straight into the higher court on a petition for writ of, let's say, prohibition to prohibit the trial court from acting any further, because they're clearly, colluding with the prosecution to deny you due process. The judge should be telling, just like Paul in Florida, the judge yelled at the prosecutor that they have to give the discovery. So that's the judge's job, is to ensure that the trial is, the arraignment, the pretrial, that the whole process is fair and comports with due process. That's part of the judge's job. And so by allowing the prosecution to not give you what's clearly relevant discovery material is certainly a violation of due process, and that could be brought up and it should be reviewed in the higher court. At least then you can get a stay of proceedings against them if you go to the higher court, which could prevent them from putting you in jail as a retaliation. They wouldn't be able to violate you in that case.
And so if I've got an FBI number, which I just recently found out I have, they just gave it to me just a couple years ago. Is that me being considered a terrorist to them? Is that why they're doing this to me? And I've never done nothing. I haven't ever done anything, anything ever that I can even think of.
Well, what do you mean you were given an FBI number? I mean, is there a file?
They've got it on my record. Whenever I go to look at everything, I look at it, and it's got your name and if you use aliases and all that stuff, they've got an FBI number there.
An FBI number. So the FBI has a running file on you, and the FBI has investigated you.
Yeah. Yeah. So does that mean I'm a terrorist?
No.
That's why they're doing this shit to me?
If they have you labeled as a sovereign citizen, then yes, they have you labeled as a domestic terrorist. Absolutely. But just because the FBI has investigated you doesn't mean that they're investigating you as if you're they believe you're a sovereign citizen. The FOIA is more appropriate to the FBI to get the information that they have in your file against you. So I would do a FOIA to the FBI and be prepared to appeal that.
That makes sense now. Okay. Yeah. That's what I'd have to do then. Okay.
Yeah. So I got to let you go, but hey, that sounds like a mess. Just keep in touch and let us know what's going on with that.
Oh, I will. I'm hanging on by here, but I will.
Okay. Appreciate it.
Okay. Thanks.
Thanks, Tom. Tom in the US of A. I guess it's a day for Tom, the name Tom. So we're going to have our old friend from the Big D back on. Tommy boy, welcome back.
Hey, Mark. Good to hear you again on a Wednesday afternoon.
You like the shirt?
Yeah, indeed.
I actually,
Absolutely.
this was when I took my daughter to her first concert last year. It was to Iron Maiden. So this one is actually the Trooper, and she actually just bought me another shirt. She surprised me, another Iron Maiden shirt, but it's Number the Beast, which is one of my favorite albums of all time. So
Right. Yeah, I'm a real Iron Maiden fan. There you go. Q and I went and saw them when they did their last tour. It's probably the same tour you saw because it was last year.
there you go.
And
Yeah.
it was a good show. The place didn't really sell out, or the crowd was good size, but it wasn't as big as I thought it would be. But anyway,
It was still a Maiden show. It was absolutely packed. They were standing. I mean, when I saw them in '87, which was just at their peak, it was the Somewhere on Tour. Saw them in Jersey. I swear I'll never see another concert that comes even close to the energy and the epicness that was that. Even when I saw them last year, as good as it was, it just was not the same as '87. I mean, if you saw Maiden from 1980 to '87, it doesn't get any better. Nobody, even Zeppelin in 1970 was still not as good as Maiden in the early '80s.
yeah, I saw them in the '80s as well.
Oh, really?
I was a real.
Yeah.
Oh yeah,
Yeah,
I was a Maiden fan I've been a Maiden fan forever. But anyway, since the show is only an hour long, I'd like to get to it. Seems that on your chat, on your August 22nd show chat, we have a pretty long thread going, 143 posts, replies to a post that Misty put out. And again, I'm not a real fan of her, but at least she puts in a lot of effort to make her points. She, in my opinion, is our best opponent, foe. She is great for role play. She may not realize that I'm using her for role play, but she's been making a really good point on this prima facie evidence, this prima facie flimsy excuse that the judges and prosecutors like to use.
Okay.
And it's so open and so easy for them to rely on that. And she, I mean, this girl puts in so much effort to posting case law, everything, you name it. It's hard to get around this. I mean, I understand the concept of how does the Constitution, how do the laws, codes, and everything apply first. We need to get there first. But they usually railroad us around that argument pretty fast, and they love to use this prima facie. Hey, the officer gave you a ticket. He gave it to you on this date. He saw you doing such and such, and you were in this area, which they consider their jurisdiction.
Yep.
So on its face value, you're here. Plead guilty or not guilty, or responsible or not responsible. How do you get around that?
Well, let's remember, I did discuss the prima facie. In no instance in recent memory, I don't remember ever having a prosecutor or a judge, whether in court or on paper, not one time do I remember them ever using the phrase prima facie in a traffic situation, ever. The issue of the prima facie being brought up is only by someone like Misty / Juan Galt. They're the ones that are bringing up the prima facie. I've got quite a lot of documents that are filed online where we've had train wrecks where things were turned down, and they have look, I could be wrong. I could just not be remembering it, Tommy. But I don't remember them ever using the phrase prima facie with me ever in court, ever.
I know I've heard it, and I can swear it came up once to me, and I know I'm absolutely positive after all these years of being here, discussing all this stuff with people, and it's because that is such a simple, flimsy catch-all. If they haven't used it with you, it'll be pretty easy to use. Well, there's the ticket. This person is claiming that you did this. Misty's argument is another one, like a civil case. If I were to claim, file a small claims case or whatever the case is and claim you did some kind of damage to me, whatever, and you were served, you would have to show up in court, or you would get or I would get a default judgment. So you would have to show up.
Yeah. But you remember though, even in a civil context, like I've quoted Iqbal versus Ashcroft, that the legal arguments they can form the framework of the complaint, but they must be supported by facts to support. So what I would do here, if they bring it out and they say prima facie, use the Socratic method. So prima facie, you say, well, doesn't prima facie mean that there has to be just the slightest possibility that these facts, if taken as true, prove the proposition? I mean, even Juan Galt admitted that, presented that on the show. So I wouldn't think that Misty could possibly disagree with Juan Galt. She practically worships the ground the man walks on. Not practically. I think she does worship, Juan Galt. That's what and I discussed this with him at length on the show. Prima facie means that it's like relevance that has any tendency to prove the proposition, even the slightest chance that it proves it. I asked Juan Galt straight out, does my physical presence have any chance to prove that the Constitution applies to me? And he said, no, it doesn't. So reasonable people, we agree, there's no reasonable possibility or possibility at all, even the most minute possibility that my physical location in Arizona proves the Constitution applies. That defeats the whole prima facie claim, but that doesn't mean they're going to do the right thing, right? The judges are going to say, oh, you're absolutely right. You're right. There's no chance your physical location can prove that. They didn't meet their prima facie burdens. It's called Abba mate. I think I did that for someone there. They're not going to do that. You know that. In some cases, yes, we've had things tossed out when the prosecutor was just left standing, to meet their burden. We have plenty of proof of that, but it's not going to happen every time. So to me, that's the easiest way and an effective way to get around that. Just ask your leading questions, because I am willing to plead guilty if there's even the slightest chance that the fact of my physical location can actually prove the Constitution applies to me. Just the slightest chance. I'll give them that. I'm not debating, and I've never contradicted them, and I've always agreed. I'll accept that principle. Just like when it comes to relevancy, it's any chance, tendency.
Well, here's one thing that I have discovered, and I stayed away from. I asked if the code applies, and such, but I stayed away from the word Constitution, because I've also heard on a lot of recordings, as soon as the word Constitution is brought in, the judge is about to blow a gasket, and you don't bring the Constitution into my courtroom and all this crap. I can see asking if the codes apply, how the codes apply to me, how the laws apply to me, and all that. But I think using that word Constitution is a real trigger that I would recommend myself to stay away from nowadays.
Well, you notice that I always start off with law. So so you determined on your own that just because I'm physically in Arizona, your laws apply and gave you jurisdiction. I get the general claim first, and then I get more specific, and then I use Constitution. Now, if the judge is going to go off the rails and start screaming about the Constitution, you can say, well, didn't you say that the laws apply to me? Isn't the Constitution the supreme law? Isn't that the basis of your jurisdiction, sir? Or let me amend that. Isn't that the basis?
I've heard the argument that we're not going to have a constitutional debate. We're not, I've heard them all. Every time somebody brings the Constitution up, or one where my judge, I can't remember exactly, it was the one that you posted the whole hearing, the one I had dismissed on your thing. I said something, I can't remember exactly what it was, a question I asked or a question he asked me and the way I answered, and he immediately went, oh, I see where we're going with this. The freeman argument, or the freeman, that's another thing that they like to corner us with.
Well, one thing at a time, though.
Sovereign citizen.
Well, okay, but the issue now, you're raising something that's very, very common, which is why we've spoken about it so many times here on the big show. When they say debate, there's a number of ways a number of leading questions we can ask them. Or we could just say, excuse me, I'm asking if the prosecution has any evidence. Why are you trying to mischaracterize that as a debate?
Right. Or they always like to also say your questions are argumentative. You know?
That is a big, yeah. Again,
he had a really good.
How is asking?
Go ahead. I'm sorry.
But you want to address exactly how? So you're telling me in your court, as opposed to every other court in the world, merely asking for evidence that the prosecution relies on, you deem that to be argumentative. How so? Explain it, bitch. Right? A little Jesse Pinkman. I'm rewatching Breaking Bad, so yeah, you're bringing out, and I appreciate it. Things that we haven't discussed in a while, but we've discussed it quite a bit. That's a very common one, and look, you have to at least make your objection, put him on a spot, and he may just say he's not going to allow it. But now you have grounds to recuse him because he's not allowing you to defend yourself. He's not allowing you to defend yourself under the guise of debating, which is not true. Asking if the prosecution has evidence to support their claim is not argumentative. Where's the argument? And if the argument, Tom, is that you're saying that the prosecution, because this is a motion, that your argument is that the prosecution doesn't have any evidence, that's a legitimate legal defense. You're in court to make argument. My gosh, this is the stupidest gosh darn thing I've ever heard, Tom. You are in court. This is the time to make legal arguments. To turn around and say you're being argumentative, it's the same as saying, I don't like you defending yourself. You defend yourself by making arguments. It is the most god-awful, stupid thing a judge can say. So this is what I would say, Tom. You know what, sir? I want to make sure that this is being recorded because I want the appellate panel to hear that you're actually going to deny me an opportunity to defend myself because you're saying I'm making legal arguments in a court of law. You imbecile.
You know, that's one of the reasons that I suggest, and I do that myself. The first thing I ask is if there's a recording being made of the proceedings, because in a magistrate court like here, I mean they've gotten it down. I've explained this before, where when you check in at the window, the lady asks you, "How do you plea?" At the window. Yeah. And I've said, I'm not here to plea, and she says, well, then I don't know which courtroom to send you to if you don't plea. So that's the first step. Then when you get to the courtroom, if you are appearing in front of a magistrate and you ask the question, is there a recording being made of the proceedings today? And they say no. Now you know this is a practice run. You know damn well you're going to walk out of there and have to come back. And if you're not careful, you're going to go to jail because there's no record. There's nothing. They're not afraid to do it. They're real tyrants. I mean, screaming at people and everything else because no record being made. That's really scary.
You got to bring witnesses with you.
Yeah. And that's so hard. Everybody works. I mean, having a friend come with you is almost an impossibility.
You got to at least try. You do the role playing, and you got to try to see if there's somebody that can just sit there with you. I know it's tough, but hey, if you have to, go to a spy shop. They're not that much money. You can get those sunglasses. They have an HD video recorder in there. They look just like sunglasses.
Well, that's always really a risk because look what happened to Bao. You know, they used the excuse to put him in jail for contempt because he had a phone on him. He wasn't even in the court. There was no one there in the court. He showed up. There was no judge, nothing, nobody. But they still charged him with having a recording device. And in many of these states, I know I talked to an attorney about it here in Michigan, and he told me it's a felony to record in the courtroom. So you got to be real careful with that advice. I wouldn't give that advice at all.
Well, it's always knowing that you're at risk. That's why I say you can get pens. This isn't one of them, obviously, but you can get pens that record. So a phone is obviously a recording device. It has been for quite a long time now. It's but a pen or sunglasses. Hey, I was tricked. I mean, 4409 a number of years ago here in Phoenix. I had no idea. I mean, unless you're looking for it, you can't tell. And if you got to get really up on those things to like, oh, wow, there is a lens in there. So you got it. That's why I say a spy shop. So you can get something that's not, that's not so conspicuous as a phone. Obviously, this is a recording device. So, yeah.
Well, there's one other problem with that, though, Mark. If you record something, okay, it's never admissible.
That's true.
Because, again, with digital days, everything can be edited. And so even if you did record it, it's only for your own personal use. It isn't going to help you at all unless you have an actual eyewitness friend or somebody with you. A recording device is useless.
Yeah, but you can transcribe a bit of that and make it look, leave some things out and then say, look, these are from my notes. This is what the guy said. So, it's some benefit there. Plus, you can always post it for other people to hear. You don't have to say, you can bleep names out and you can post and say, listen to this. This is what happens in traffic court. And this has to be stopped. I do want to address one issue, though, that was brought up by someone pointed out that Misty made a comment and they keeps accusing me of getting Rule 701 wrong. It's not, I'm not getting Rule 701 wrong. I'm just not necessarily using it as a front and way she's talking about. When I'm asking for the facts that the police officer his claim that he just testified to, the facts that his claim is based on, and they object on grounds that it calls for a legal conclusion. Yeah, you can say what Rule 701 allows it. You can say that, but to me, I don't think the judge is going to magically say, "Oh my God, oh my gosh, you're right. Holy crap, we've been denying people effective cross-examination for 20 years. No, I think it's sufficient, and it should be sufficient, and it has been sufficient in the past. Not that you can say Rule 701, but point out, like we always do, Tom, I didn't ask him to make a legal conclusion. I asked him for the facts his claim at the stop was based on. It's not an on-point. The objection is off point. The prosecutor is not saying Rule 701 doesn't allow that testimony, Your Honor. He's not saying that. It's for you to say, oh, no, it does allow it. He's saying something that he's misdirecting. He's saying that you're asking a question you didn't even ask. And that is sufficient. But, you can always say, Rule 701, even if I am asking to make a legal conclusion. I'm asking him to restate his testimony. So I don't think I'm getting it wrong, and I don't think it's because I'm so emotional or that I'm just, my ego is so friggin' large. I don't think any of that's true. I think it's because if somebody makes an objection that's completely off point, it's just enough to say, that's not the question that I asked you, dickhead. I didn't ask him for a legal conclusion. And Rule 701 is completely irrelevant to defeating the objection because the prosecutor is lying. That's the way I see it.
Yeah, she, I like her passion and I like her efforts, but she does flip back and forth a little bit. I'm trying to get on the same page with her, at least let's agree on something and work together and move forward from there. And she did make the comment in that thread that she, her issue is with victimless crimes. Well, that's exactly what all these are. I mean, if you're, stopped for speeding and haven't injured anyone, or rolling through a stop sign at 2 a.m. at 2 miles an hour and there's no one around, or, smoking a doobie or whatever, these are all victimless crimes. And she just, I don't know. I like her and I hate her all at the same time. She's a great opponent.
Well, what I would say,
opponents we've had.
I think you're probably better off, and I think I mentioned this before, take it onto the forum. Just post it on the forum. At least there, other people get to see it, and other people, can participate. And if she wants, hey, I gave Juan Galt, they can lie about why if she wants to come on the forum and just continually lie about the work instead of just criticizing it, yeah, that'll get most people blocked, which it's only happened like 3 or 4 times. But she's welcome, like anybody else is, to contact me on the website. I'll set them up with an account, and they can have at it. And then, you can embed the video into a new thread, and then it's easier to go through. And then you can post. It's easier to post responses, and so. But I just noticed the time, and I got another caller, so I'm going to try to get another caller in. Hey, good material though today, Tom.
All right, thanks.
Appreciate the call. We'll see. Oh, great. I dropped Tom, and my other caller dropped off. So just a nice time. So I'm going to leave the caller line on there for just a bit. Maybe they'll call in, because this issue of 702 of the evidence code, that I'm not using it because I'm an emotional egomaniac. Yeah. I don't like when innocent people get killed and no one's held accountable for it. I don't like abuse. It tends to get my Sicilian up. But that doesn't mean that I'm incapable of having a rational discussion. I mean, I got plenty of evidence on here and on the website that's just not true. It's an excuse not to confront me in real time. And at least one Galt had the guts to do that. Of course, it was not a professional call, because he didn't stop interrupting me, but still, I kept my word, and I did not cut him off the show, and I did not use the mute button. So at least I kept my word about being professional that way. But the idea that of 701, go ahead. I would suggest that, if you want, but definitely make your point that when okay, so you ask if the police officer determined that the laws applied because you were physically in Arizona, and that gave him jurisdiction. And he says, yes, that's exactly what happened. So he confirms that. When you ask in the follow-up question, what facts, did you rely on to prove that was true? What facts was your determination based on? And then the prosecutor jumps up and says, objection, calls for a legal conclusion. The witness may not testify, or is unqualified to testify. First point out, excuse me, the prosecution is being dishonest now, and is mischaracterizing my question. My question asked for the facts his claim was based on. It goes to his prior statement. And you can say, and just for the hell of it, I don't think it's barred by Rule 701 or 702. Just, throw that in as an afterthought and report back to me and let me know if all of a sudden judges start saying, holy crap, Misty's right. It doesn't matter if they go, yes, oh my gosh, yeah, Rule 701. I'm going to do the right thing now. We've used Rule 602 that the witness didn't have personal knowledge. They let it happen anyway. So maybe if we throw that in as an afterthought, at least maybe there'll be more success if we have to appeal. Maybe appellate judges will look and see, they'll ignore the part that the prosecution actually lied, that the objection had nothing to do with the question. And they could say, oh, well, but we're not going to, whoa, we don't want to hear that the prosecution lied and that the judge bought it anyway. Rule 701. I'm very skeptical the judge is going to do that. I think we have more of a chance, and we've shown success on appeal where the prosecution has lied about it. But a very good example of where we point out that the prosecution clearly lied and did not make an on-point objection is with Rebecca here in Chandler, Arizona. Even on appeal, the judge absolutely insisted that the question called for a legal conclusion, even though they quoted the question. What facts did you rely on? Calls for a legal conclusion. That's why you say abafungo, because they don't care. If they are willing to, in those situations where they're willing to lie for the prosecutor and back them up on an objection that was clearly off point, that had nothing to do, was not rooted in reality, had no basis in the rules, I am very skeptical that they're going to see that you quote Rule 701. Because the question was not asking for a legal conclusion. So if the judge is going to lie, if two judges are willing to lie on behalf of the prosecutor, are they really going to say, all of a sudden say, Oh, 70. But hey, I'm all for it. You know, if you want to put 701 in, I'll start recommending that. Do it as an afterthought. The prosecution is lying about my question. I didn't ask for a legal conclusion. I only asked for the facts. I can have the court reporter read it back to you. And if you're going to, back them up on that, then Rule 701 it's clearly permitted. So we'll see what happens. Hey, we're at the end of the big show. Appreciate all the calls that we had today. We had a lot of good material there. I will be live on Saturday, live from the fortified compound in, what is it, San Bernardino, California there, but we will be live for the 3 hours. So whoever we may have missed today, definitely call into that broadcast. This was episode 77, live from the fortified compound in Mesa, Arizona for August 29th, brought to you by my good friend, Bill in New Hampshire, and also Dan. And I do appreciate the support of the show. You can also do that at markstevens.net. It is very much appreciated. Thanks, everyone. I appreciate the time. Until next time, as always, salud.